Let us now proceed to hear from the speakers for the sub-theme 1. In the sub-theme 1, first we will hear about Japan's border enforcement measures, Ms. Yokogoshi, from the Customs and Tariff Bureaus of the Ministry of Finance.
Good afternoon. My name is Ayu Yokogoshi from Customs and Tariff Bureau, Ministry of Finance, Japan. First of all, I would like to express my sincere appreciation for the opportunity to speak at this symposium. Today, I will talk about the customs border enforcement on IPR in Japan. And this is the table of contents of my presentation. To start, let me outline the border enforcement. Let me briefly explain the legal framework. Under the customs law, the export, import, and transit of goods that infringe IPR are strictly prohibited. In addition, there are penal provisions for such offenses. Anyone who exports or imports or attempts to export or import infringing goods may be subject to imprisonment for up to 10 years and or a fine up to 10 million yen. As for the scope of infringing goods, it is defined by the respective IP laws, such as the Patent Act, Trademark Act, and Copyright Act, administered by the relevant ministries and agencies. This slide shows the scope of border enforcement of IPR. In Japan, IP right holders can file an application for suspension with the customs. Through this procedure, the right holder can request customs to suspend the export or import of suspected infringing goods and conduct a verification procedures to determine whether the goods in question actually infringe their IPR. This system enables customs to take proactive action at the border based on the request and information provided by right holders to prevent the distribution of counterfeit and pirated goods. To submit an application for suspension at headquarters of regional customs, a right holder is supposed to fulfill the following 5 points. First, ownership of the right has to be proved. Second, the IPR has to be valid. Third, the IPR has been infringed or is likely to be infringed. Fourth, evidence has to be provided. And fifth, information concerning the goods has to be provided to enable customs to verify infringing goods. Although the fifth point is not an acceptance requirement, customs still requests that applicants submit these materials. With these points and materials, the application is approved with a validity period of not more than 4 years. Also, existing applications are renewable. This slide shows the number of valid applications for import accepted by Japan Customs, broken down by the type of IPR. Trademark-related applications account for the majority of all cases. However, in recent years, the number of applications concerning patent rights and design rights has been increasing. Next, when customs officers detect goods that appear to be infringed IPR during inspection, they conduct a procedure to determine whether the goods actually constitute infringing goods. This procedure is called verification procedure. The process for import cases is shown on this slide. When customs find goods suspected of infringing IPR, it issues a notice to both the right holder and the importer, informing them that certain imported goods may include suspected infringing items. Customs then requests both parties to submit their evidence and opinions regarding whether the goods fall under the category of infringing goods. either party wishes to examine the goods in person in order to prepare their submission, they may request permission from customs to inspect the goods. After receiving the evidence and opinions from both sides, customs carefully reviews the materials and makes a determination as to whether the goods constitute infringing goods. When the determination is technically difficult, customs may seek expert opinions, for example, from other government agencies such as the Japan Patent Office or the Ministry of Agriculture, Forestry and Fisheries, or from external experts such as patent attorneys and lawyers. During the verification procedure, the importer may also negotiate with the right holder to obtain consent for importation or voluntarily abandon the goods. And in cases where an application for suspension has already been accepted, a simplified procedure may be applied. As shown on the right side of the chart, before asking both parties to submit their evidence, customs first confirms whether the importer intends to contest the alleged infringement. If the importer does not raise any objection, customs may proceed to determine the case without requesting additional submissions from the right holder. As a reference, this table shows the number of verification procedures conducted by Japan Customs. In total, there have been around 33,000 cases of verification procedures. Among them, simplified procedures account for approximately 8 to 9% of all cases, representing the vast majority. This indicates that, in most cases, importers do not contest the infringement, allowing customs to make determinations efficiently under the simplified procedures. There are several factors that may explain this, but I would like to introduce the recent legal amendments aimed at strengthening Japan Customs' response to counterfeit goods imported through e-commerce channels for personal use. In recent years, with the evolution of e-commerce, an increasing number of counterfeit products are directly sent to individuals by business operators. Previously, importing counterfeit products for personal use was not prohibited, as the Trademark and Design Act only applied to business activities. However, in May 2021, Trademark Act and Design Act has been revised, and bringing counterfeit products into Japan via postal mail, etc. by overseas business operator has been defined as infringing on trademark and design rights. In response to this amendment, customs law was also revised in March 2022. Then, even when intended for private use, counterfeit products infringing trademark or design rights sent to Japan by overseas businesses cannot be imported from October 2022. Next, I would like to outline the seizure results for 2024. In 2024, Japan Customs suspended a total of 33,000 cases of infringing goods. It is the highest figure since the publication of such statistics began in 1987. In terms of the number of articles, Japan Customs seized around 1.3 million items in the previous year. And this slide shows the seizure results by mode of transport. The graph on the left indicates the number of cases, and as you can see, postal parcels account for the vast majority, 87.7% of all cases. On the other hand, the graph on the right shows the number of articles. As you can see here, the number of items seized from general cargo shipments is larger than that from postal parcels. Next, this slide shows the seizure results by country of region or region of origin. Looking at the number of cases shown in the graph on the left, around 80% of infringing goods originated from China, followed by Vietnam, Malaysia, and Korea. As for the number of articles shown on the graph on the right, shipments from China also account for about 70% and showing a similar trend. And this slide shows the Caesar results by the type of IPR. As you can see in the graph on the left, which indicates the number of cases, trademark-related cases account for about 90% of the total, representing the overwhelming majority. Similarly, in the graph on the right, which shows the number of articles, trademark infringement also make up the largest share among all categories. Finally, in the third and last part of my presentation, I would like to talk about Japan Customs cooperation with right holders and e-commerce platform operators. With regard to cooperation with right holders, Japan Customs promotes proactive border enforcement based on information provided by right holders through applications for suspension. We also work to enhance training programs for customs officials to help them identify counterfeit and pirated goods more effectively, and to improve the convenience of procedures for right holders. Lastly, let me touch on our cooperation with e-commerce platform operators. The Customs and Tariff Bureau has signed memorandum of cooperation with major platform companies, Amazon Japan in 2022 and Rakuten Group in December 2023, to strengthen information sharing and collaborative efforts in preventing the import and export counterfeit goods. Japan Customs recognizes that close collaboration among multiple stakeholders, including enforcement authorities, e-commerce platforms, and right holders, is essential for effectively tackling counterfeit trade through online channels. Going forward, we will continue to enhance cooperation with relevant stakeholders to make border enforcement more effective and efficient. Thank you very much for your listening.
Thank you very much, Ms. Yokogoshi, for your presentation.